The Patriot Act and its predecessors, security, surveillance, and the legal tightrope. 1. Historical precedents for emergency security laws. Throughout American history, perceived threats to national security have prompted legislative action that often encroaches on civil liberties. The Alien and Sedition Acts of 1798, enacted under President John Adams during tensions with France, enabled the deportation of foreign nationals and restricted press freedoms. The Sedition Act criminalized criticism of the government, revealing early federal willingness to prioritize state security over individual rights. Jefferson and Madison opposed the acts, invoking state sovereignty to challenge unconstitutional overreach. Though most of the legislation expired by 1802, the Alien Enemies Act survived and was later invoked by President Franklin Roosevelt during World War II to intern Japanese Americans, proving that once created, such powers rarely vanish quietly. Footnote. This section outlines the early legislative tendencies to sacrifice constitutional freedoms during perceived national emergencies. 2. Pre-9/11 legal landscape, from Oklahoma to the Anti-Terrorism Act. Before 2001, U.S. law enforcement faced domestic and international terrorist threats, including the 1993 World Trade Center bombing and the 1995 Oklahoma City bombing. These events culminated in the 1996 Anti-Terrorism and Effective Death Penalty Act, which sought to expedite legal proceedings for terrorism suspects. However, President Clinton's request for expanded wiretap powers was denied due to constitutional concerns. Congressional reluctance stemmed from fears of overreach, a pre-Patriot Act commitment to due process, evidently not sustainable under pressure. The stage was set, all that was missing was a sufficiently traumatic catalyst. Footnote. This section examines how domestic terrorism shaped early federal attempts to expand surveillance and punitive measures. 3. The Patriot Act of 2001, crisis as catalyst. In the aftermath of the September 11 attacks, the U.S. Congress rapidly passed the USA Patriot Act, a 342-page legal omnibus signed into law on October 26, 2001. Officially titled Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism, it provided broad powers to law enforcement and intelligence agencies. Key provisions included expanded wiretap authority, including roving wiretaps, delayed notification search warrants, access to financial and communication records, and interagency intelligence sharing. The act eliminated the statute of limitations for certain terror offenses and extended federal jurisdiction across state boundaries. Footnote. This section details the legislative response to 9/11 and how the Patriot Act reshaped federal surveillance capabilities. 4. Legal expansion versus constitutional retraction. While the government framed the Patriot Act as a necessary evolution of pre-existing anti-crime tools, critics labeled it a constitutional wrecking ball. Concerns arose regarding Fourth Amendment violations, surveillance without warrants, and the erosion of due process. Civil liberties organizations argued that innocent citizens could be surveilled, detained, or even prosecuted without adequate legal protections. Defenders of the act pointed to thwarted attacks and the FBI's enhanced operational efficiency, citing cases such as the 2010 Times Square bombing attempt. Yet, the Department of Justice admitted difficulty attributing major counterterrorism successes directly to the Patriot Act's more controversial sections. Footnote. This section highlights the core legal and ethical tension between state security enhancements and civil liberty infringements. 5. From Patriot to Freedom, Revisions and Legal Pushback. In 2015, the U.S. Court of Appeals for the Second Circuit ruled that Section 215 of the Patriot Act did not authorize the bulk collection of Americans' phone records. This judicial slap on the wrist led to the USA Freedom Act, signed into law by President Barack Obama on June 2, 2015. The Freedom Act ended mass data collection under Section 215, improved transparency, allowed limited emergency data access, and slightly enhanced public oversight of the FISA court. Critics, however, remained skeptical, arguing that reforms did not go far enough to rein in surveillance overreach, a sentiment echoed in cases of abuse like falsified FISA warrants against U.S. citizens. Footnote. This section explores the legal recalibration from mass surveillance to moderated oversight through the USA Freedom Act. 6. Patriot Act effectiveness, security gains versus civil risks. Law enforcement agencies cite the Patriot Act as a key contributor to intelligence gathering and prevention of terrorist activities. High-profile cases, including that of Faisal Shahzad's attempted Times Square bombing, are often used to justify the legislation's efficacy. Shahzad was identified, tracked, and apprehended due in part to expanded investigative tools. Nonetheless, audits, such as a 2015 report by The Washington Post, question whether key surveillance provisions actually led to prosecutable cases. The Act's utility may lie more in its potential than its practice, a rather expensive form of national insurance. Footnote. This section weighs the Patriot Act's operational success in thwarting terror plots against criticisms of its actual effectiveness and civil costs. 7. Abuse and aftermath, lawfare, FISA, and political weaponization. Allegations of abuse have undermined public trust in national security surveillance. Notably, the FBI's misuse of FISA processes to surveil U.S. citizens, including political operatives, exposed systemic vulnerabilities. Sworn affidavits containing false information, targeting political figures, demonstrated how tools designed for national security could be repurposed for partisan objectives. These controversies reinforced civil libertarian warnings: unchecked power is prone to misuse. The legacy of the Patriot Act is therefore not confined to terrorism, but includes a broader commentary on governance, accountability, and the fragility of constitutional protections in the face of executive expediency. Footnote. This section addresses the weaponization of surveillance law for political ends and the erosion of institutional credibility.